Hi, this is attorney Joe McPeak with Virtuoso Criminal and DUI Lawyers. Let's talk about what it takes for the government to prove somebody guilty of reckless driving under this statute. Reckless driving under Vehicle Code 23103 requires the government to prove that you drove a vehicle in a willful way with some sort of reckless or wanton disregard for the safety of other people or property. This last part is where a lot of the contentiousness can come in a reckless driving prosecution. It's not enough for the government usually to just prove that your driving was bad, or even that you were necessarily driving illegal, for example, above the speed limit. They have to prove that your manner of driving was in some sort of conscious disregard of the possibility that other people or property may get hurt. So in situations where somebody may be driving very poorly, but in a really, really wide open space where it's unlikely that other people's stuff would get hurt, or it's not likely that anybody else was coming into the field, well, that might not necessarily be an ideal reckless driving prosecution. On the other hand, if somebody were to say, for example, drive at an unreasonably fast speed, that could be one of many factors. They're doing it on a highway, for example, where there's other cars or maybe other people in the street. Those are examples of cases that could make out for a reckless driving prosecution. They also have to prove that the driving was willful. So an example where somebody perhaps falls asleep in a parked car and then accidentally they slump onto the controls and then the car moves forward, that's a dangerous situation. But with those facts being proven out, you may not have a willful action, and so therefore the driving, although bad and dangerous, would not really be considered willful. There are two types of reckless driving, one which is called wet reckless, the other which is called dry reckless. Reckless driving under this section is often referred to as dry reckless as opposed to wet reckless. Let me tell you why. The term wet reckless often comes up in the context of DUI prosecutions because, as you might know, if you get a DUI reduced to a wet reckless, you get the benefit of having a less severe looking charge on your record, reckless driving instead of DUI, but because it's flagged as wet reckless in the records, that means that if you get arrested for DUI again, then your reckless driving case could actually count as a prior DUI for calculating your sentencing. One thing you should know, just like convictions for DUI and for wet reckless, a conviction for dry reckless under Vehicle Code Section 23103 does put 2 negligent operator points on your driving record, and they will stay there for 3 years with the DMV, and those could cause your insurance costs to be higher. That being said, a reduction to dry reckless from a DUI can often, not always, but often be a favorable outcome because it does not show as any type of DUI-related conviction on your record. I hope this is informative. Feel free to give us a call anytime for a free consultation at 1-8336-NO-JAIL. And also feel free to check out our YouTube and Instagram sites.